Yeah. Can you connect me?
Yeah, can you?
Can you connect my computer?
Yeah, because he is now connected on the phone. So, welcome, thanks for coming. We think now we have enough of an audience to get going. We're being counted. Some
Recording in progress.
I heard an echo. Now it's gone. Oh yeah, I think you all need to mute yourselves and yeah, or maybe now it works. Let's see. Yeah, great. So our presenters are there. You are here. We are here. Great. Thanks. I hope you enjoyed the morning program. I did a lot, and I was thinking about this issue that was raised about is this language of the social contract, does it mean anything to people on the ground? And I was actually thinking, well, maybe not that language, but this sense, this longing for that people have to have a government that is trustworthy and that they can expect something from, and the sense of deprivation when people don't have that. To me, from the places I visited, I recognize that quite a bit, actually. So welcome to this session that is co-hosted between LANDac, the Dutch Land Academy, and Land at Scale, a program executed by RVO on behalf of the Dutch government on land tenure security and good land governance. We've together with Wietske here, who is a coordinator of the knowledge management component of that program, compiled this session. When we saw the theme of this conference, we thought this is going to be a very interesting venue for us to discuss about land issues because of a number of reasons. First of all, land issues matter a lot to people, so to have, let's say, a responsive government on those issues matters a lot. Also, we have seen how land registration efforts, programs to promote land tenure security have gradually been moved in many parts of the world more to the local setting. So that opens up an arena at which maybe we might see a renegotiation of relations, accountability relations, responsivity of local governments, hopefully legitimacy around these land services and interventions. So that's what we hope to explore with you today, with a number of speakers from different land at scale projects and a number of statements which we will ask you to reflect. So we will have presentations, discussions, and we hope it will all work. Let me take a peek at my notes. Yeah, my name is Gemma van der Haar. I forgot to start where I should have started by presenting myself. I work at Wageningen University on issues of development, land, and conflict. I'm also a co-chair of LANDac since a couple of years, and in that capacity engaged with the Land at Scale program. And we have three distinguished speakers, all with a lot of experience in the field of land governance and directly part of some of these land at scale projects. Now I will present them one by one as we go into the respective statements to which they will be speaking. And I have an elaborate time schedule for today, which specifies 5 minutes for this, my introduction. I think it's already gone. 2 minutes for this, 2 minutes for that, 5 minutes. So I will be looking a lot at my clock here, and I have to apologize from the start for having to be strict from time to time, especially to them, but maybe also to you. We have our speakers online, but the audience only right here. You are able to respond to the statements that we will be showing in a few minutes, one by one, through this wooklab.com. So you can already start connecting to that on your phones, and then when the statement comes up, it will be easy for you to respond right away. The order is we have yes. Well, yeah. The session is recorded, so I formally have to tell you this also to allow you to leave in case you would want that. Another important thing to note is that for the sorry? Or to send it, oh, of course, that's also, yeah, to decide what you would and would not share. In the discussion, it's a small room. It can be very informal, yet we will need to use this microphone for the recording, but also for our speakers to be able to capture what you're saying. Did I forget anything technical? No? Good. Did you manage to? I haven't tried myself, so thanks again, Wietske. Wietske is the coordinator of the knowledge management program of LANDac and the mastermind behind this whole thing. Yeah. So let's see how it works. So I think it's time for statement. I have too many papers here. Before going to statement 1, let me introduce our first speaker, and that's Alexandra Emirusenge Edlam. I hope I pronounced it okay. I didn't try this one yet. A sector specialist on land rights with ZOA. Also, maybe I shouldn't say this, but used to be a student of us at Wageningen University. We're finding them everywhere. She has worked on several interventions in Burundi over a period of 7 years and currently coordinates for ZOA the Amahoro at Scale project, which is part of Land at Scale, in partnership with VNGI and MIPAREC on improvement of land governance in Makamba. Now, yeah, I think we can welcome you with an applause, Alexandra, also because you stepped in at the last moment because our original speakers at the last moment couldn't make it. So let's welcome you. And then the statement first, right?
Excuse me.
Sorry, Alexandra, we're almost, because I also have to introduce it. The first statement is land registration offers key opportunities to local governments to strengthen the local social contract. So the idea here is that hypothetically, we're not saying this is happening, you will be debating. Hypothetically, land registration services and interventions may work in analogy with other kinds of services delivered at the local level, that they might work to harness the legitimacy, to harness the capacity of local governments. So this is the first statement we would like to discuss and see whether land registration at the local level could be a lever to improve trust and trustworthiness and accountability relations. So as you think about your opinion about that, let's listen to Alexandra. Now it's your turn. And go ahead. We are very interested to hear what you have to share with us.
Thank you very much, Gemma, for your introduction. Please confirm if you can see my screen at the moment.
Yeah, we can.
Okay, thank you very much. So I would like to share with you a little bit more on the land tenure registration program going on in Burundi under the Land at Scale program. And it's called Amahoro at Scale. Amahoro is the Kirundi word for peace. So we're focusing also on contributing to peace in Burundi under this program. And we have, yeah, in this presentation, I will specifically also focus a bit more on strengthening the local government through this process. But before that, I would like to share a little bit on the context in Burundi, which is relevant for working on land rights. There's a very high dependency on land and agriculture for survival. 85% of the population is directly dependent on the land. And there is a high population density, which creates together with that dependency a large pressure on land. And the current situation is that on average, a household has less than half a hectare to cultivate. Concerning documentation of land ownership, this is very limited still at the moment, although there's different processes going on. But there are some other papers going around, which are often referred to as petit papier, but they are not widely recognized by all the institutions, so creating more confusion than clarity often. There's a large influx of returning refugees, Burundian refugees returning back to their family land since 2007, mainly from Tanzania, which creates a lot of conflicts over land as well with people that they find already living on their land. But also there are many conflicts over land within families going on. And in Burundi, the land administration system is decentralized to the district level, where there's local cadastre services who are responsible for the land registration and certification process. But we observe that there's a lack of capacity of these local cadastres and also lack of means for them to operate their tasks. So about the Amahoro at Scale project, the overall objective is to contribute to the improvement of land tenure security and land governance in Burundi. And we focus on the Nyanza-Lac district in Makamba province, which is all the way in the south of Burundi, bordering Tanzania. But we go a little bit further than only that district, as well as we think of developing a strategy for scaling up and improving land governance even on a national level. The partners with which we work, first of all, the district governments and even other levels of government. But the organizations that we work with, Gemma already introduced them. Actually, it's SOA, more on the technical land registration process, VNGI, which is focusing on good governance and lobby and advocacy. And our local partner, MIPAREC, which is expert in conflict mediation and awareness raising on community level. So the program started with an inception phase on the 1st of December last year, and now it's in its first months of implementation. A short schematic overview of the approach. There's 4 outcomes, which the first 2 are really focused on the Nyanza-Lac district to roll out the systematic land tenure registration process, supporting the government to roll this out, basically to technically support them to be able to roll this out. And the second outcome is focused on conflict resolution mechanism capacity building of local structures to be able to do conflict resolution on land conflicts during and after the land tenure registration. And then outcome 3 and 4 are more on a higher level, where we are going to develop a strategy for scaling up under outcome 3 to develop really a sustainable, technically sustainable, financially viable model for the service foncier communal, the local cadastres, to be rolled out basically in the whole of Burundi. And then the 4th is on creating an enabling institutional environment for improving land governance in Burundi. And throughout those 4 outcomes, we are also trying to link to other third party programs to create synergy and complementarity so that the impact of land security goes together also with, for example, themes as access to justice, access to finance, and inclusive food security. So that's the setup of the program. Now, focusing a bit more on strengthening the local government. First of all, on the district level or commune level. So it's basically the district level, the district administration who requests for ZOA or for any actor to support them on rolling out the land tenure registration. And it's the district that will really decide upon it and request this support for the land tenure, for their land tenure registration activities. And it's the district administration that should always be and remain in charge of this process. And Land at Scale then supports the district administration to really further operationalize the local cadastre. As in many districts in Burundi, they exist, but they lack really capacity to carry out their work. And with Amahoro at Scale, there's a specific support also from VNGI, especially on accompanying the district administration to make their processes more participatory and more inclusive towards the community they serve. And this is, for example, done by workshops with the district administration on participatory budgeting of the district administration. And the project also included the judicial system by organizing a workshop with lawyers and judges in Nyanza-Lac district to discuss and exchange on complex land conflict situations in the district, and also on harmonizing a bit the interpretation of the land certificate and the different types of land rights that are registered on there. So that was the district level. And then on an even more local level, the village level or colline level, as said in Burundi, here we are engaging mainly with the CRCs. They are by law, by the land law, decided to be the Commission de Reconnaissance Collinaire that are responsible for all land registration processes on the village level. And they consist of 7 members, of which 4 are actually locally elected members. So real local government people. In second place, we engage also with the traditional authorities, which are called Bashinganahe. And yeah, they are traditionally the institution on the village level that deal a lot with conflict mediation as well. And then there's a third newly created institution on the village level, which is called the Conseil des Notables. It is like a local council, which is said to be replacing the customary authorities, but is still very much in the beginning of the process, and many things are not yet clear, but we hope to engage, we plan to engage with them as well. And how do we engage? It's mainly through training and capacity building on the land law, that they know exactly what is in there, on the procedures of land tenure registration, and especially also on conflict mediation, as they are the first people that the community will go to for conflict mediation. There's some challenges, especially focusing on the relationship with the communities, between the communities and the local government. What was found in the baseline study of Amahoro at Scale is that people fear losing their land rights because they have the idea that the commune, the district, is trying to urbanize more and more and modernize, and that through that process they might lose their access to land. Secondly, there's also been conflicts coming up between the state and individual landowners when the state lands were registered. That was a preceding step before Amahoro at Scale can go to the collines to register the private lands. And in these conflicts, it's the state who claims the land of those local landowners as theirs. And conflicts arose from that. So for now, that process has stopped until the conflicts will find solution. We have seen in other districts, because in Nyanza-Lac we're not that far yet, but we know the challenge is that there's a limited registration of land transactions after the initial certification process. So this might mean that after a while the database might be out of date. And also another challenge is that especially on village level, there is quite a rotation of people in charge in the CRCs, especially, that are being re-elected every 5 years, or even within that period there might be changes which make us feel like the capacity that we built in those people might move away as well. So that's also a challenge. And as I mentioned before, the role of this new local structure is unclear yet, and it is to be seen how this will relate, how they will function, how that will relate to the already existing other local structures, and how the communities will accept them as a new structure. Then to conclude with some results and impacts. Also, this is more from previous experiences, as Nyanza-Lac project is still really in the beginning phase. But we have seen that communities and authorities have really increased their knowledge on the land law, on land rights, and particularly also on the protection of women's land rights, and on the whole procedure and the different steps in the land tenure registration process. The administration of the districts have declared also that they've seen a reduction of land conflicts that are being addressed to them, to the district administration. And we see that local farmers now are able to get a loan based on their land certificates. And through that, they are able to invest more in the land and extend their agricultural activities. And finally, also, we've seen an increase in the registration of women's land rights. although there's still room also for improvement in there. So thank you very much. That was it from my side. Giving the floor back to you, Gemma.
Thank you. Thanks a lot also for keeping to the time. I think your presentation has clearly shown how land registration comes with many changes for local governments, interventions directly targeting their capacities, but also changing things in the institutional makeup. What might that mean for the relations between local authorities and their constituencies? That's what you're going to tell me, audience. Can we call up the first? You just vote. Do you remember? Ah, there it is. Is it working? Yeah, have you voted? Because they're not showing up yet. Yeah. Okay, we are so far a hopeful audience. You hope to see that. So counting down, if you want to vote. Yeah. Okay, this is, I think well, we'll leave it there, but I'll start talking. I don't know actually if the people online, our presenters, can see the outcome, but we have of 9 people voting, they agree, land registration offers key opportunities to strengthen the local social contract, and 2 who disagree. Now I'd like to, because we have only 10 minutes, so it's good to get to the controversial issues first, and see also whether Alexandra would like to respond to them. Those who disagreed, would you share, would you care to share your hesitations about the statement?
Yes, I was afraid of that. So actually, I don't really disagree with the statement because it's quite conditional. I mean, it says key opportunities, but it doesn't say land registration will strengthen this. But still, I thought, let me be on the side of people who question things a bit. So I'm always a bit ambivalent about land tenure registration. And that is because it has clearly opportunities to improve many things in the communities where it happens, on an economic front, but also on a social front, and even in a sort of a governance perspective, perhaps to strengthen the social contract. But it has the real potential also to produce some significant bad effects for women. It has the potential to increase rather than decrease disputes. That could also lead to violence. And I guess the how that pans out. So is the net effect positive or is it negative? And can you is it fair for often you as an outsider to say that, well, so many positive effects for these people can sort of cancel away the negative effects for those people? But how that pans out depends on a whole range of sort of conditions that prevail before you start, relating to how capable are the institutions of local governance who are going to deal with this. For how long can they sustain the whole initiatives, even if a donor were to withdraw its funds? How much is all of that affected by corruption? Alessandra speaks in a very politically correct way about a new institution that has been created, but there's actually really fundamental problems with that tie deeply into Burundi's ethnopolitics, and so yeah, I find it. I think yes, but personally, I'm yet to see the good example. So maybe that's why I hesitate.
Thank you. You are.
I'm a lawyer and Patricia van Ispen, and we are implementing microjustice. I think also that this question, because you are an expert on Burundi, and likely in the Burundi context, the whole capacity building process is cumbersome, conflictuous. In general, in this world, I really think and we propagate that everyone registered their lands and their belongings. We are starting now a microjustice program in Egypt. In Egypt, less than 5% of the population, including in Cairo, has registered their property. Huge problem. I agree with you. Yes, it's a huge problem to start the entire process and to keep it updated also, no, because that's another problem what came up in Burundi. It is useless, no, if it's not, but we have to do it right. And I really appreciate your initiatives at LANDac to have a fit for purpose kind of approach, depending on the local context. But I think always that the legal component is missing, and we would like to offer our help in that also.
Thank you. This is a crucial debate that always comes up. I would like to, so going back to Marco as well, saying, yeah, it might actually do. I would like to go not just to the issue of land tenure security, but what might these programs do in terms of the relation between local constituents and their governments? Did anybody have see opportunities there, or reflect on what would it take for that to happen? Could we have could we have reactions on that?
Just sorry, I actually voted agree, but Marco's comments had me reflect a bit. I would problematize a bit the notion of a local social contract, because in highly centralized societies where power is very much concentrated at the top, and I don't know Burundi well enough to know if that's the case, but my suspicion is that it may be. The notion of a local social contract implies that these type of local level measures will be attributed by people that are benefiting from them to decision makers at the local level. And I'm very skeptical about that. I think in the end, people in highly centralized societies will always be looking at the top and attributing any change that has been experienced to decisions that were made at the center. So to the extent that that changes social relations or the balance of power at local level, and whether people in communities really see local governments as having provided that change, again, I'm really skeptical. But I don't know the context well enough. I guess I'm speaking more in general terms. Thanks.
Yeah, to me, I think that's a core issue that you touch upon, and I would hope Alexandra would be able to react to it. Let's see if there's another perhaps reflection around this. Oh, Marco can't. Yeah.
Yeah, also to say something positive, because I must admit also that in a past life I worked together with Alessandra and Corina and Zoa also on Burundi, and I actually thinking about it, I'm also somewhat positive about the statement, because one of the things that Alessandra referred to was women's customary rights, and actually one of the very good things that I saw the program doing in the past when it discovered that initially not so many women's land rights were being taken along in the process, essentially you have a situation where customary law on the same plot of land can attribute rights to various people, men and women, and usually in the registration process in the beginning only men's rights were being noted down. And so there was a whole process in Makamba to sit with communities to reflect on what would it mean if registration were to come to their community, what had happened in places where women's rights were excluded in the process, and what they thought of that and how they could organize as a community their thinking around, okay, what needs now to happen in our community. And actually we saw at that time the level of recognition of women's rights springing up significantly, multiplying. So maybe that's a good local social contract example.
Yeah, on the dimension of that horizontal local contract making, let's say the idea of who belongs and who has rights in a community more inclusive. I think maybe this is a good time to go back to Alexander. There's those two issues. How do you think this pays off? So on the, let's say what has been called the vertical social contract on the local level, do you think, or are you taking any measures to see whether your work with the districts and the communes actually pays off in terms of their responsiveness and their legitimacy locally? But also the other question brought in by Marco, how do you work with this notion of the horizontal strengthening the inclusivity of that local social contract, if we like to keep that metaphor? I think those are great questions for you, so go ahead.
Yeah, on the vertical level, I think there is at the moment where we see the most challenging situations. And in the past, in the previous, before Land at Scale, we really focused on working with this local cadastre and not so much with the district administration, even though they were the one basically deciding upon it and being in charge also of the local cadastre. But in Land at Scale, we've chosen now to work with VNGI. That is a new partnership for us in land rights, and especially to also work with the district administration to be more accountable, to have more participatory processes in place, more inclusiveness. So I think in the past, we've not yet seen a very clear improvement maybe of this legitimacy throughout the process. And that's why we chose now to have more focus on it within Land at Scale, also on the good governance side. And what I see as a challenge in it, what we've seen in the past, that often people start saying ZOA is doing the land, is handing out the certificates. And this is a dangerous thing, I think, because we always say we are just supporting the local cadastre, but populations still see it differently, and that might harm the legitimacy, I think, of the local government. So that is a real risk that we try to overthrow also. Yeah, and as I showed, some challenges also that have come up, that there's still some suspicion within the communities in Nyanza-Lak at the moment towards the district administration of how they are going to use this process of land tenure registration, especially the fear of urbanization, that they might lose access to land, and that in the end, it's, even though they have a certificate, maybe at some point indeed the higher hierarchy will decide otherwise, and there's still fear of losing that access to land maybe. So I think there's really still challenges there. I think on the horizontal level, I think we see really an improvement, especially the example I cannot see, and I did not hear exactly the name of the person who was speaking, but I think it's someone from IDLO who did
Marco
indeed.
Lankhorst.
Yes, I thought that must be Marco Lankhorst. Yes, so indeed we are applying in this Land at Scale program also the approach that IDLO piloted in a previous project on especially protection of women's land rights. And we've seen in the past indeed that has really improved the consensus on the community level about the protection of these land rights of women, the customary land rights of women. And so I think there we've really seen an improvement also with the local structures in place, that we try to engage really with the official formal CRC authorities, and also the traditional customary authorities, that they both have a place in the whole process and in the conflict mediation as well. And then again, as mentioned, this new structure that is initiated by the government, that is still very sensitive and to be seen how that will work out. And we really try to follow up and try to see what the best way is for LANDac to engage that new structure as well.
Thanks a lot, Alexandra. We close this first discussion here. You got me worried there, Simon Peter, because you just disappeared when it was your time to come up. Thanks a lot, Alexandra. That takes us to the next statement and the next speaker. The next speaker is Simon Peter, a land tenure advisor with the Global Land Tool Network and UN Habitat. And he coordinates that network's land governance work in Uganda. Also very experienced, over 10 years experience as a land tenure specialist, working in land administration, property taxation. That's a very interesting one in this context of the social contract. And working with private and government agencies. So Simon Peter, I'm just first again going to show the statement and explain the thinking behind it, and then we go to you. So we entered on the positive side for the first statement, but some in Alexandra's answers, you already heard, and from some of you as well, but what if you don't have a good starting position in terms of local government, and you then come in with your land registration programs? What happens? The word corruption came up, the word fear came up, I think, when Alexandra was talking. And that's also something we want to talk about, and phrasing it like this: where local governments lack capacity and accountability, land registration might produce serious risks. Simon Peter has about 10 minutes to give us some elements to judge that based on his experience from Uganda. And the floor is yours now, Simon Peter.
Thank you, Gemma, for that introduction. I hope you can hear me. My internet is acting up.
We can hear you well.
Great. So I will discuss this question, sharing our experiences in Uganda. And in my presentation, I will set the context in terms of these issues in Uganda. Discuss a little bit on the institutional framework of land administration in Uganda, and then the challenges also for the local government to deliver on their mandate, and then what we are doing under LANDac scale project in response to some of the challenges, and then the risks that could happen if local government don't have the capacity and accountability, and then I'll give some concluding remarks. So as an introduction, I hope you can see my presentation. I'll try to put it in full mode.
We see it perfectly. Yeah.
Okay.
Oh yeah. Yeah. Perfect.
Great. So here I just wanted to say that the work that we still have to do on land tenure security is still a lot. Only in many developing countries, only 30%, sometimes even much less, of the land rights are secured. In the case of Uganda, as you will see, it's much below the 30%. And yet land tenure security is very critical for achieving most of the sustainable development goals, including on reducing hunger, poverty, and management and sustainable management of natural resources. So for those of you who don't know much about Uganda, it's a small country in East Africa, but with a very high population, and the population growth is really very high, 3% per annum, and most of it is rural, and yet it has one of the highest urbanizing rates, 5.3% per annum. And most of the population are youth, young people below the age of 30. And the land tenure system there is also very complex with 4 tenure systems. Milo is one peculiar one to Uganda, but in principle, that's a feudal system with landlords and tenants. And then majority of the land is under customary land tenure system, as is in most of sub-Saharan African countries. The challenge is also there that there are systematic inequalities that affect women access to land, as well as young people. And in fact, if you consider the registered land, only 3% of the land is registered in the names of women. But here we are talking about freehold, leasehold, and partly Milo. And the land disputes are also on the rise. In fact, it is estimated that in every 1 in every 4 rural farms are in some sort of a dispute. And of course, with the increasing population, as well as food security needs increasing, there is more than ever increasing pressure on land and natural resources. And yet, local governments have to deliver land services in Uganda. Since mid-1990s, the land administration system is decentralized. So you have sharing of the roles between local government and central government. And in fact, in this structure, as you can see, the local governments initiate most of the land registration and land administration functions. So the central government will not be able to provide services unless they have been initiated at local level. Now, while the local government is responsible for many of the land services, their capacity is very low. Very often, they lack the staffing that is required to provide the land services. But also, the other issue is that even when the staffing is in place, they are not trained, and they also lack resources to be able to perform their functions. And this is really a very big challenge. But also, if you look at this structure, there are some land administration institutions that were created. For instance, the Area Land Committee and the District Land Board that play a very critical role, because the Area Land Committee is responsible for land adjudication and mediation of land disputes at the sub-county level, while the District Land Board is in charge of approving all land registration applications. However, these are politically appointed, and they change as often as politicians change. And so one of the challenges there is also that there is no continuity. And also the selection criteria is also not very clear. So usually you find that the political appointees are selected without due consideration on their capability, and they lack capacity to be able to do this function. The other issue here is related to, and I think this is also very critical, because the lack of capacity is mainly due to limited funding at the local government. So the local government still rely heavily on central government conditional grants, and they have very limited own source revenue. So in the face of limited revenue, the land sectors usually are ranked down in terms of priority compared to other critical sectors such as health, education, infrastructure, and others. But as a result of all these challenges, what we have in place in Uganda are relatively very progressive laws and policies that have been in place for many years, and they have potential to secure land rights for majority of Ugandans at scale, but with limited implementation. And also what we also see is that out of many years of frustration of communities going to local government offices to seek for land services and not being able to get them, there is an increasing culture of mistrust of the local governance and their capacity to be able to deliver the services. But also the local governments have become agents of those who can afford, the rich, and investors to facilitate them to acquire land, but also to register their land rights, while leaving out majority of the population. And also there is limited awareness of the communities about different options to secure their land rights. So in the context of Land at Scale Uganda, what we are doing, we are building on experiences from a pilot project that we implemented from 2018 to 2020. And the goal here is to contribute to development of a structured and scalable approach towards improving tenure security and sustainable land use for at least 30,000 smallholder farmers. And in terms of how we want to achieve that, one of the key strategies of the project is to use fit for purpose and gender responsive land tools that are available to be able to build capacity of local government to be able to deliver securing of land rights. But also we combine that with tenure responsive land use planning that is participatory, because what we see in the past is that even when land rights are secured, land use planning that is top-bottom could compromise the security of those land rights, especially if planning is done without due consideration of its implication on land tenure security. The other thing that we try to do is to make sure that we restore the trust between the community and the local government.
We lost you for a bit. Are you there?
Which I said before that, and also trying to make sure of visualization tools. Hello, can you hear me?
Yes, you were cut off when you said you're seeking to build the trust between citizens. Maybe you could repeat that. Yeah, and then you have one final minute to close up.
Okay, so we are building the trust between the communities and the local government. We are also using participatory approaches to be able to, to make sure that the communities are involved in the processes of land registration. We use a lot of visualization tools. We make sure that the process is community-driven. Also making sure that the outcomes go back to the communities for validation, as well as including the traditional governance structures, which is in the traditional conventional land registration process left out. And then one other thing that we also do is making sure that we do awareness raising and community engagement, not as a one-off activity at the beginning of the intervention, but to make sure that that is continuous throughout the activity. If you will allow me, I will use my last minute to say that this process is really very critical. And in fact, I would argue that the products, that is the certificates and the land use plans, are as good as the process itself. So if the process is not done well, then the products that are out of this process are also not good. And in fact, they pose a lot of risk for the communities and could do more harm than good. One of the risks that we see if the process is not done well is that, one, the communities could boycott the process. In the past in Uganda, what we have seen, especially for the conventional process for registering freehold and individual titles, was some point the community became violent towards government officials and government surveyors who went to register land without engaging adequately the community. The other risk that we see is, and we know this, that land is highly politicized. So there is need to have political champions. There is need to make sure that before you do any field work, including mapping, that the community, the political leaders have bought into the process. But also, as you mentioned, this process could, risk that it excludes certain groups of society, women, for instance, and girls. So making sure that you build the capacity of local government, local government to make sure that they conduct a gender responsive process, I think is very critical. And also the other risk we see is that if this process is not done well, it could result into more disputes. One example is if you do not involve all the neighbors and make sure that you allow adequate time for counterclaims to be registered and resolved before you do the mapping and registration, that could result into more disputes. And so in itself, the process becomes self-defeating. And then also, one of the things we have and we take cognizance of in Uganda is that we have communal land rights. We also have areas where customary land rights are individualized at nuclear family level. So in those areas where customary land rights are communal, it is important to make sure that everybody that has the claim is involved and is registered on the product, which is the certificate of customary ownership, or is part of the communal land association that is being incorporated to manage that community asset. So that is really very important. And also, I think in the earlier discussion, they alluded to another important point, making sure that the land records created are going to be updated, I think is really very critical because land records get outdated as soon as they are created. Sometimes even before the certificates are issued, there are many changes that happen. And so there has to be a mechanism to be able to register those changes, to make sure that those records are not, they stay alive and serve the purpose. And lastly, I want to say that the big elephant in the room is corruption, which we know already in Uganda. The land sector has been ranked for many years as one of the most corrupt sectors in the country. And so if the process is not as transparent and accountable as it should be, then that could actually propagate more corruption, while the intention is, to create more accountability as well as transparency. That may not be achieved if you don't make sure that the process is actually as transparent and involves everybody as it should. So as I conclude,
that was a long minute. It was worth it, but now you have 20 seconds. Sharp.
Thank you. So as I conclude, I think capacity building for local government land administration institution should always be a key component of land registration interventions. We know that capacity building is not just about creating technical capacity for the land administration institutions at local level, but also it should include mindset change. It should include giving them capacity to be able to plan better and to deliver on those plans, but also have a bigger vision of what they want to achieve for the community, as well as changing their work ethics and culture, which is not really easy to change, as well as changing the social norms, especially where there is gender bias. And we know that this takes time. Unfortunately, the reality of projects such as the one we are implementing, they are time bound, but there is a need to make sure that you have a long-term vision of how you will be able, and strategies of how you'll be able to achieve this. And make sure that capacity building is not just a one-off activity, such as a training event, but to make sure that it is continuous throughout the program or the project. And lastly,
yeah, Simon, I'm really going to cut you short there. I told you you would hate me.
Thank you.
I gave you already some
Thank
leeway,
you, Gemma.
but I think you will also want to hear the discussion. We
Sure.
are
Happy to discuss further. Thank you.
yeah, thanks a lot for your contribution, pointing out quite a number of the critical issues. We are going to vote real quick because now we all know how it works. The statement was, I guess it's going to be pulled up where you can see it. Okay, so let's see how the votes come in. I think Simon gave us quite some elements to think about this one. Everybody has voted who wants to vote? So, Simon, you might not be able to see it, but we have 7 people agreeing about their serious risks, and 1 so far disagreeing. Yeah, so I think you did a good job in pointing out some of these quite critical issues. Now I'm going to ask the audience, now if we are so conscious of these risks, as most of you are they worth taking? Or what does this risk panorama imply then? Now, if this is what you think, what does that mean for how we approach these topics? Anyone?
Thank you very much. I think it's really obvious that land registration, if there's no accountability, it's going to produce a lot of risk. And because I'm from Nigeria, and looking at Nigeria's context, in terms of, you mentioned like whose name is going to be on the registration, and most times land rights, it starts from the family, where the family, they have this intra-family disputes over who owns the land. Maybe it's inherited, but then the father only passed it on to the children, and then the children starts to fight among themselves. And then also you see the eldest person, maybe the man who is the eldest son, goes on to say, and if he has money, he goes to the registration, and then he gets the registration in his name. So and then it excludes others. So whose name is going to be on the registration? So these are some of the things government need to really put into consideration. And then also even in Nigeria, the government put a clause when it comes to land registration. When government sees that the land, for some reason, government can reclaim it. And that has always been a conflict between the local communities and the government, because suddenly the government will come up and say, oh, we saw this is so strategic, we want to beautify the community, and so we need to take back the land, even though they've registered it. So that clause itself does not give that much confidence to people to say, okay, after registration, government cannot come back to take the land. And then the issue of tax also comes in, because if people register the land, particularly women who are just from like let's say not rich women, but they manage to register the land, and then just once their name is on the database in Nigeria's context, they start getting taxed. And these are women, maybe they're just using the land for farming. And then, so what happens? So many people also refrain from even registering the land because it attracts more cost for them. So these are all issues that government need to put into consideration if they really want to get that social confidence from the population. Yeah.
Thanks for that and for adding the tax issue. Perhaps Simon might want to respond on that one. Who was the outlying voter in this one? Let's not miss the opportunity to hear your arguments.
Yeah, I did that so that I'd get the microphone. Yeah, if you vote with a gang, you don't get the microphone. No, I just I sort of did it to rub a little bit against, everybody agreeing with the statement, because I thought if you put a no in it or not, then it was sort of true as well. So where local governments lack capacity and accountability, not working on land registration produces serious risks and whatever is covered there by the screen. Yeah. So I don't think, I agree with the reasons for voting yes or agree, but surely doing something is better than doing nothing. And so, I think it's too maybe black and white to say, we either do it or we don't do it. And I think paying attention to land registration is what's needed, right? So that's what I just wanted to actually highlight by voting no or disagree. And the other thing is talking about fragility at this conference. Liz Truss just resigned, so it's very exciting.
Okay, thanks for throwing in that. By the way, before I go to you, did you also have your hand up? Yeah, okay. Maybe just to can I participate in the debate? I'm the chair. Well, good. I think I would like to hear what people think about this. Yeah, not doing is also risky. Yeah, but does that then mean that how do we weigh then which of these risks are worth taking and which are worse? Anyhow.
So I'm obviously quite biased, because we've been talking a lot about Burundi, and coming from there, I have a couple of ideas and perspectives on the country, but I just wanted to insist on the point mentioned by Simon on the processes. Land in many countries can be like a polarization factor. So if governments, lack either capacity or accountability and do something, or as you were saying, do not do something, you in both cases create some sort of vacuum, a lot of loopholes, and that vacuum would actually offer opportunity for instrumentalization and politicization, and the social fracture would even get deeper. So I would say you have to do something, but it's all about the way you do it and how you are sensitive and cautious with regard to a lot of factors like the history of the country, the social divides, and how it has evolved, all over the years. Yeah.
Thanks for that addition and for picking up on what I think was an important contribution from Peter to focus. So if you have a process that's wrong, your outcomes will be wrong. I saw you, Marco, but I would like to go back for a moment to Peter to reflect on what you've heard, and then I'll look at my watch and see if we have time to go to you. So maybe something on taxation and something on the political rifts, perhaps.
Thank you, Gemma, and thank you all for your reactions. Whose name is it going to be registered? In our case, the law allows everybody to be registered. If it is managed at nuclear family, everybody in the family is registered. If it's managed at extended family level, then everybody in the extended family is registered. But if it is beyond And if the resource is a community resource or a clan resource, then it's impossible to register everybody in the clan or community. And in that case, the law allows them to incorporate into a communal land association. And so it's the name of that communal land association that will then be registered on the certificate. Of course, the process of incorporating a communal land association also includes deciding on how the association is going to be governed. And that's also a very critical process to be done. There was a question on tax. That's very interesting because I'm always arguing also that land administration and land registration is a very profitable activity in the sense that it generates revenue for local governments. And so as we see in the case of Uganda, the registration fee is quite small, around 10,000, which is around $3. But that $3, if you consider the scale that we are implementing this activity, it results into quite significant resources for local governments. And that's one of the incentives why actually local governments are engaged in it. But in our case, we don't have a land tax. And what I understood from your question was that if there is a land tax, then it has to be clear if the registration process will not result into communities being, asked to pay that tax. And I think that varies from one jurisdiction to another. But I also strongly argue that taxation is not a bad thing if the tax is equitable, if the tax is used in an accountable way, because taxation also creates, I think, the social contract that we have been talking about. Because if I'm paying the tax, then I need also services in return. I need you to be able to meet some of the needs of the community. And I think that is in many ways the social contract that we are talking about. And land taxes and property taxes are easy to trace and audit. They are very easy to trace and audit. And I think it's an important issue also to look at here. Lastly, doing something is better than doing nothing. I think it depends on that something you are doing. If I have land rights through a customary land tenure system and we own a piece of land, 10 brothers or 10 siblings, and you come and register it in let's say 5 of us's names, and 5 of us lose out our land rights, I think it's very difficult to explain to the other 5 who have lost out their land interest that doing that registration is better than not doing it. I think it was better not doing it in the first place. So I think we have to be careful. What are we doing and how that is going to impact the land rights of those that we intend to secure their rights. Thank you.
Thanks a lot. Thanks a lot. And let's give you some hands as well. And that leaves us the last 20 minutes to go to the final statement. Let me introduce our third speaker. Is he there? Yeah. Mr. Fidel Masengo, National Field Program Manager leading the Land Conflict Resolution Project in Rwanda, and also within the RVO Land at Scale project. He is an advocate, arbitrator, and certified mediator. So very, very qualified to talk about the next topic, which is about dispute resolution, and in particular, alternative dispute resolution. We have heard the word conflict and dispute coming up. There's a high incidence of disputes around land, and there are many institutions dealing with these. And this is what this last topic is about. If we get alternative dispute resolution mechanisms as a response, possibly to a bad performance of formal dispute resolution mechanisms, then what does that mean? And here, yeah, the problem is put on the table. Does it not first and foremost promote authority struggles? This is the one you get to think about, and we have 10 minutes with Dr. Fidel Masengo to, yeah, to enlighten us with his position and experience on this topic. The floor is yours. I'm not sure now if you are going to be able to share your screen or we have another arrangement. You are doing it? No.
I think I'm able to do it.
Oh, that
You
would
will
be
tell
good.
me if you are you seeing it?
Not yet. I think it's
If
coming.
now,
Yeah, yeah. Just put it on slideshow, I think, and it will be just
yeah,
perfect.
that's fine.
Wonderful. Yeah. The floor is
Thanks a
yours.
lot. Thanks a lot for introducing me, and I'm going to try to keep the time and to allow people to have their observations and comments. Actually, ADR, Alternative Dispute Mechanism, is PRILA itself. You know, there are many mechanisms that are enfolded in the concept. Among those, you know, varieties, you can see mediation. They're what we call abunzi, which is kind of mediation, but that has also adjudication in it. There are also many other, I can call them mixed mechanism, whereby you see mediation, arbitration, adjudication mixed, and some are, you know, well regulated by the legislation, whereby others are not regulated by legislation. They are just created by the practice. And I'm going to just assess the strengthening or undermining of the local social contract by those ADR mechanisms. Before going further, I want just to tell you that, as I've said, we have many ADR mechanisms, but we also have many actors that are involved in land dispute resolution. Those actors, according to our recent research of 2022 in June, we've found that there are at least 5 actors that are involved in land dispute resolution. Some are formal, others are informal. Abunzi committees is a structure that is formal. Those are like mediators, but as I said, they are also allowed to do adjudication whenever people cannot reach agreement in mediation. There are local leaders at various levels, from Umudugud, which is I call it the hill or the colline in French, up to the district level. You know, you can also the cell level and sector level. Those are different local leaders. We have family councils. Family councils are, it's a structure that's an informal structure. You don't have this codified, and you can't even know who is the member of the family council unless you have a dispute. That's when you will know that each family has its, call them its judges or its a dispute resolution actors. We have, of course, formal courts. That's a primary court for many issues involving land, but for some land of big importance, you can go also to, you know, higher courts. There is also what we call maison d'accès à la justice. Those are, you know, it's a structure that has been put in place by the government to help people to access justice. We call them Access to Justice Bureau. Those are not people that solve the dispute, but they can help people to facilitate or orient people to structures that will help them to solve the dispute. When we did the research, we came to observe that you know, we're like trying to compare those different actors, those that are involved in land dispute resolution, based on what justice seekers gave their responses, we came to observe that the big number of people who deal with land dispute, local leaders comes first with 29%, Abunzi committees 28%, family councils with 17%. So you go primary courts with 13%, land committees and MARCH, Maison d'Accès à la Justice. Those are the responses from the justice seekers. But when we talked to land committees, this is local elected people who are at the grassroots level, they ranked Abunzi committees higher, 39%, local leaders 35%, and families at 18%, primary courts at 9%. When you see on average, the difference is not really big. So this means that Abunzi committee, local leaders, and family councils are the main actors in charge of solving land dispute. Now, briefly, what are their roles and the composition? Abunzi committees are elected people from the local community members. Local leaders are also elected. Some are elected, but others can be appointed at the lower level. Family councils are not all of them elected. Even if in some family they can have some mechanism of designating them from the family lineage. The roles of the Abunzi committees to mediate and sometimes adjudicate. They start by mediating, and when mediation fails, then they can adjudicate, and they can, their decision can be enforced even by the legal means. For local leaders, they are not formally given the role of solving dispute, but we'll have them do it on a daily basis, even if it's not written, if they do mediation. So they play a key role. They can even send people to other organs. For the family councils, no regulation, no law that gives them the role, but we'll find that they have traditional authority to solve dispute. We tried to see the satisfactions of the service that are provided by those. If you see the satisfactions, you'll see that Abunzi committee, especially, we found that people are satisfied with what Abunzi committee do. So this means that Abunzi committee are trusted by the local population. And we also try to know if the outcome of their decision can lead to solve the issue. We came to realize that they can even reach through conciliation. And you see this at 87%, 92% from the female respondent and 85% from the male respondent. This means that the work done by Abunzi committee can reach to the true conciliation, which is really good, rather than having one win and one lose. For the family council as a strong informal dispute resolution organ, that's where issues comes. You have an organ that is not regulated, that's not provided for by the law, but that has a key role. Remember, we say that it's the third institution after Abunzi committees and local leaders. So despite the promotion of any informal mechanism, the role of the family council in land conflict resolution is still significant. And they are said to be the guarantor of family harmony because they play a key role in conflict resolution. They are also regarded as the manager of economic viability of family land, where people have like common shares on certain land. And they have also the sociocultural coherence and continuity by playing a key role some rituals aspect of the family lineage. They can say this land will not allow people to build on this land because it has some restrictions. So there are some collaboration mechanisms between Abunzi, family councils, which is really good. There are possibilities for informal partnership between the two institutions, which is also good. And there are also involvement of family council in implementing Abunzi court decision. And they can be also sort of consultation between the two organs. There are some benefits linked to informal ADR mechanism. Those benefits are the fact that all of them play the role in land dispute resolution. If there are many, it is a good thing because at least people can access justice. And based on the composition, you will see that many of them are coming from the community elected people, and having both formal and informal mechanisms increase community awareness of their land rights and the involvement in solving dispute. That's also another thing. Again, combining formal and informal ADR mechanism increase opportunity for collaboration and complementarity. There are some disadvantages. I can mention only 5: overlapping jurisdictions, possible contradictions in decision-making, lack of coordination because some are not regulated, possibility of forum shopping whereby people will choose to go to this institution rather to another one, lack of clear definition of roles of the family council, and the risk of conflict of interest for some members who can be, in family council, in Abunzi committee, as well as local leaders at the same time. There are some challenges, difficulty in assessing the performance of informal land dispute organs such as the family council, risk of gender discrimination, especially for the family council, which is patriarchal in great majority, and lack of accountability compared to formal organs, compared to Abunzi. Lack of trainings, family councils members are not trained, yet they have a role to play, but MARSH and Abunzi committees and judges are trained. Loss of interest by justice seekers in informal land dispute resolution because the decision is not binding, risk of non-compliance with law due to ignorance, and the risk of applying customs that are contrary to the law because people don't know the governing legislation. So recommendation, which is my last slide, we've found that there are some recommendations that can be proposed, such as conducting an awareness campaign, informing people both about formal and informal ADR mechanism, that the government has to do this with also civil society organization, create a coordination mechanism targeting both formal and informal ADR mechanism, and where possible, insert some informal ADR best practice in governing legislation rather than just having informal and formal. It's better to make sure that legislation includes some best practice from the informal practices, strengthening the relationship between formal and informal ADR mechanism, especially the referral mechanism. That's what I can share from now. Thanks for your attention.
Thanks a lot. Great. And I also noticed some time disappeared from my, but anyhow, we will quickly put up the statement, and I think you gave nicely elements to think about both kinds of outcomes. So I'm curious to see what people will vote this time. If you would quickly do it, I'm not going to ask you for a prediction. They can't see it online, I think, what we are doing. So they're voting now for the creation of alternative dispute resolution mechanisms for land conflict, promotes authority struggles between government and traditional authorities. No votes in yet. Difficult one, yeah. So the alternative dispute resolution mechanisms would be here rather than on the governmental side. So are they, so basically you can read this, are they a good addition, ensuring a better access to justice, like Fidel said, or are they perhaps creating more conflictivity because of these different options and more clarity? Ah, yeah, 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 yeah. Yeah, I can see what you mean. So the alternative sounds like it's completely new rather than, yeah. So So adding alternative dispute resolution mechanisms to the mix, do you see that as something positive in the sense of allowing people better to address their disputes, or do you see it as something negative because of the, let's say, institutional struggles it would generate and whatever that might mean? So that's the positive. And then, so we are divided 50-50. Okay. Okay, point taken. But it is an extremely important question, as I think most of you will realize, and I think Fidel did a good job in showing us both sides to it. I think also to do justice to, so if you look beyond the wording of the statement to the topic itself, could we have someone from the cautious side and someone who says, no, but we should have this because it, yeah, and then, so I take two and then
Well, it depends. I think that it's alternative dispute resolution is only useful if it can be taken as a decision, no? If the authorities, so if it cooperates with the final authorities. So if you have alternative dispute resolution, and in the end it is still the government institutions that won't validate it, then it's useless, I think. No, there must be one line within a country for conflict resolution. So yes, alternative, cheaper, easier conflict resolution, but only if it can be validated by the judicial bodies on a higher level and implemented, executed also.
this is close to you, right? I'll go to the back and then yeah.
Very shortly, just wanted to say that like the first to contest, this kind of mechanisms are the people on the legal side, the harsh ones. So you really, really have to do a lot in convincing judges and legal specialists. At least in some countries, I know they can be, they can have like strong arguments about this kind of mechanisms.
Yeah, which would undermine their effectiveness in practice. Yeah.
Okay. I won't fall into the temptation of still giving my reflections on the previous question then. So I think we need to distinguish land dispute resolution during the process of land registration and land dispute resolution after the process of land registration. So during the process of land registration, which is not the situation that Rwanda would be in, obviously, but perhaps parts of Burundi would be in, what I often see, not only in Burundi, but in many places, is that ad hoc dispute resolution mechanisms are created in the fashion that is reflected in your question. And that I have serious issues with, because it is neither socially grounded nor properly linked to the formal justice system. And that creates, so land dispute resolution, when it's undertaken at scale, it produces a massive amount of disputes. So the reason for creating an ad hoc mechanism, I understand it very well. But usually these are not, this is done by local organizations who are not absolute experts in the subject matter, and it creates a lot of problems. So the lack of linking there, either with traditional, I'd rather say with traditional and formal, that is an issue. And then after after registration, so perhaps in the situation where Rwanda is now 10 years after the act, it's also an interesting thing to look at. And there, so questions like, are you able, if you get a decision, to have the decision enforced? Are you do people have access to proper legal counsel to get there, to know first of all what their right is, and to then go to an institution that knows how to deal with it. Is there a way of addressing the corruption that very often plays a part in all of this? And I think in our analysis of whether we do land registration, and maybe I still come back a little bit to the previous question, we don't always anticipate the necessity to work on that part. Because if I end up in registration with a certificate and 3 years later I have someone who's encroaching upon my land, and I go to court and I show my certificate, but the court isn't aware of the novelties in the law and doesn't accept my certificate, or the court is bribed and doesn't care about my certificate, or I get the court judgment, but I can never enforce it because no one will help me with that, then we've spent an enormous amount of money on land registration, but it's worth nothing.
That's a very important statement on which to end. Fidel, Dr. Masengo, I know some people are going to rush to coffee, but I would really like to give you the opportunity to, oh, are you there? To respond to
Yes,
the
I'm
issues that
there.
have been brought up in a concise manner, but please, please do.
Yeah, actually, I like the previous intervention. In Rwanda, you have to understand it's not a good place to measure the question because we don't have ADR mechanism that are very separate to traditional authorities. Our ADR mechanism have included all traditional dispute resolution. So now we have a situation whereby I call it legal pluralism in technical terms, where we have the governing legislation that has included the practices that were there before the legislation. So in that such a case, ADR will not see, will not come to empower government rather than empowering traditional authorities. And there is no creation of competition between courts and ADR. They are rather complementarity, sort of, because remember, Abunzi members are elected, but Abunzi members who are elected from the community, they were supposed to be using the traditional mechanism. Now they are also trained to apply the legislation on Abunzi, which has also included the current practices. To me, it's a perfect system that allows both the government institutions, the traditional system, the courts, to cooperate. That's what I can say. But for other countries where you have written legislation different with traditional practices, of course, we'll have conflicts. But for our case, Abunzi applies legislation, but they also apply best practices because the legislation has given them that mandate, especially during mediation. So when they go to adjudication, that's where they can follow the legislation. Yeah.
Thanks a lot for this very clear answer. Let's applaud our three speakers. Thank you all, also a highly expert audience here. Thanks for engaging, and rush off to coffee, I think.